Robert, so you brought it up. You sort of predicted this before it was even predictable. And I took some flack from friends and family who say, be careful. Don't make these suggestions because you look like an apologist for some criminals. Say it's not necessarily an apologist because couldn't even see that far ahead of the curve. But now we're there. And now we know the details, which is 12 plus informants with FBI agents who are, some of these informants are being paid $55,000. I don't know if it's annually or whatever. They're being paid to not just infiltrate, report back, to actively lead. They are given leadership roles by the FBI. They're training. They are, to say that they're suggesting or inciting or encouraging is an understatement. They are basically infiltrating, a militia. This one's called the Wolverine Watchmen. And they're basically egging them on in terms that are so active and so proactive, it's shocking. But they're taking leadership roles in training, in running, whatever they call them, the test runs to go check out the properties. And then, lo and behold, they arrest 12 people and run up the charges that they did. And the question even BuzzFeed is asking is, would there have even been a conspiracy but for the proactive involvement of the FBI and the informants? Robert, the legal question is this to me. I think I know the answer, but I probably don't, and I'm sure others don't. When does investigation become entrapment? What is that threshold in law where they cross the line?
So under the Sixth Circuit Court of Appeals jury instructions based on a Supreme Court change to entrapment law in the early 90s, a different Jacobson decision, a better Jacobson decision, that was Jacobson versus the United States, is that the two factors are, did the person already have the idea before the informant appeared, before the FBI or the informant appeared? And that's the first step. So, were they already going to commit it and somebody infiltrated a criminal organization already dedicated to the crime? And then the second part is, did they instigate or persuade any aspect of it? Here, what's becoming clear is that both of those elements, and the government has to prove to the jury beyond a reasonable doubt that those two facts. And so some people get confused because of affirmative defenses. There are affirmative defenses in civil law where you as a defendant bear the burden of production of evidence and proof at trial to whatever the standard is, usually the standard, sometimes clear and convincing evidence, usually it's just preponderance of the evidence. In a criminal case, that's not the case. Even if something's labeled an affirmative defense, it really doesn't mean that. It only means that for the purpose you have to give notice to the government and the court that you're going to raise this defense. But once it's raised, it's the burden of the government to disprove it beyond a reasonable doubt. So they have to what they have to now prove is that all of these defendants already had the idea to do this before the informant showed up, when all the evidence is none of them had the idea to do this until the informant showed up. And if they didn't.
Oh, sorry, just to stop you there, because before I knew what militias meant, and what it means in American society and Second Amendment concepts, militias, I know what they look. I know what I think they look like as a Canadian. And I picture, what I see in Afghanistan, Iraq, and whatever. In the United States, a militia does not necessarily refer to the same entity that we conceive of it as in other nations. Is that roughly accurate?
Oh, absolutely. In the United States, they're just political organizations that are named after the Second Amendment. That's all they really are. And so the modern, quote-unquote, militia movement sort of started in strength in the 90s. And by the way, it started in strength in the 90s after the FBI decided to create their own militia to instigate militia movement in the United States called PACCON that they hid for almost 20 years from the public. And I talk about it in one of the Hush Hush episodes at vivabarneslaw.locals.com. But so they're just political movements, the political movements who believe in the Second Amendment. So the idea is that you have an obligation to protect your country under the Second Amendment, that the militia can be called up. There's a federal statute that still authorizes Congress to call up the militia, which includes 17-year-olds, by the way, that thus has interesting Second Amendment implications in other contexts. But yeah, they're not like militias everywhere else in the world, which are actually armed insurrectionist movements generally.
Okay. So because when we first heard this, they infiltrated a militia, people are going to have the same impression that they have when they read articles about residential schools and mass graves. These terms evoke specific connotations, but this is a group, a bunch of guys, doing whatever. I say doing whatever because, people form these militias. They call them militias because they want to hang around and talk about Second Amendment stuff and the U.S. Constitution. But when they say they infiltrate a militia, it already sounds bad. But by the sounds of it, they infiltrate this militia of guys who, by and large, did any of them that we know of have any criminal histories or meaningful criminal histories?
Well, that's one of the 5 factors they consider under entrapment law in the Sixth Circuit is their prior histories. And to my knowledge, the only people that had extensive prior histories are the FBI informants themselves. So including now the lead FBI agent running it, who's like something right out of a James Elroy novel. In that, it turns out he had a side hustle, his own little side businesses going on. He was involved in swinger parties. He was apparently, he's now been charged and arrested for a severe assault on his wife. And this is the guy that's kind of heading one of the key head people involved. One of the other key head people, by the way, that approved all of this was promoted after this and ended up being heavily involved in the January 6th investigations. So it's an interesting connection. Maybe just coincidental, some people would say. But what's showing up is that
I would say other people would say there are no coincidences, but sorry, Robert, go on.
Yeah, not with involving some 3-letter agencies, but they to my knowledge, they've already met the first element because what's also extraordinary is it's like the January 6 cases. The government's hiding a whole bunch of evidence. They've seized the defendant's own phones and electronic equipment and have refused to return it. I mean, these people were arrested back in October. So, we're almost 9 months, whatever it is, into the process, and they don't even have their own records of their own statements yet. I've never even heard of something that egregious for a case like this. And they've been trying to hide because apparently they accidentally discovered. This is how you really get discovery in defense case. It's almost always accidental when the government turns over something. I had a case like that where they had assigned a privileged taint team, and the privileged taint team thought this was tainted material they should return back, not knowing what it really exposed is the government had been involved with secret informants spying on the criminal defense the entire time. That case got a satisfactory resolution ultimately. But
in this case, for anybody who doesn't know the issue, and it was in the motion to compel discovery of the defendant Cabrera, I think that's his name, where they apparently got a 4-page truncated text exchange between the informant and the FBI agent, basically saying, this is what I want you to go out and do today. Get as many people as you can to go on recon. That's the word I was looking for. To go on recon, to get involved in training, get as many people involved as you can, because the more you can get, that would be a good day. But they only got like 4 pages of this text thread. Apparently, the government is not producing the exchange in its entirety, which was part and parcel of the motion to compel discovery. So that's what you're talking about for anybody who doesn't know in that context. So they get this document. It looks like very active participation, interaction between the informant and the FBI agent.
They're instigating it. They're promoting it. I mean, like the FBI informant ends up being mostly in charge of this. He ends up number 2 in charge of the whole organization, which gives you an idea that it was a pretty loose organization. It was a political organization is what it was.
No, he becomes number 2 within the 8 months or the 5 months that he's involved, because it's, there's that much of a hierarchy to run up. Okay, so the criteria for entrapment: history of the individuals, instigating or inciting the actual act. What else is going to go involved into that consideration?
Oh, so they look at how much promotion there was involved, how much instigation there was, how much the defendant, was involved in prior criminal activities like this before or after. They look at whether or not certain actions of the FBI. I mean, was the FBI just watching, or was the FBI instigating? Was the informant just watching, or was the FBI, or was the informant instigating? Here, just the little bit they got, it was all being instigated by the FBI and the informant. All of it. And there's no evidence that I've seen so far that any of them had this idea at all before the informant shows up. And that's your classic entrapment case. Like, a famous one is Marion Barry. They wanted to get Marion Barry on tape smoking crack. So they set him up with one of his mistresses. And he says no like 8 different times. But she's like, if you want to have some fun, you're going to have to smoke it. He's like, fine. Finally smokes it. That's classic entrapment. He clearly wasn't, despite the fact he may have had a history with it.
Well, because I was going to say, you're going to have to do a little more than twist my rubber arm to get me to smoke crack. Because if I've never done it before, I'm never doing it ever. So I would imagine anyone who begrudgingly agrees probably has done it before, because that's not something you begrudgingly agree to do for the first time type thing. But yeah, okay, totally. I mean, I remember the Marion Barry scandal. I didn't know anything back then. I was ignorant. I was the kid who didn't know how to ask the question. because I didn't even know that the question needed to be asked.
Yes.
Okay, sorry.
So they have
So go on with the entrapment. Yes.
They're clearly hiding this evidence because it's more exculpatory than inculpatory. There's no doubt about it. You don't need to hide evidence that makes the defendants look bad. You need to hide evidence that shows that the whole record and track history was this was an FBI created event, FBI instigated event. That's the meme that's been on our locals board where it's they unmask everybody and everybody's the FBI pointing at the FBI.
Yeah, that's it. I saw a better variation, which was ordinarily it's just two Spider-Men pointing at each other, but there was one who was 6 guys, all FBI. I think there was one non-FBI agent in there. But yeah, this is coming out that there are more FBI agents and informants than alleged perpetrators. And it seems that none of these perpetrators, I have not heard that any of them had any meaningful criminal history, if any. And I imagine that would have been the first thing that would have come out, because first thing you want to do is make them look like criminals, career criminals, which they don't seem to be. And there was an article on the Cabrera, the one who filed the motion to dismiss, where they said that, they referred to some of his anti-government posts on Instagram. And I watched those videos, and to refer to that as to suggest that is anything incriminating in a criminal sense is an absolute abuse of the word anti-government messages, where that's just stuff that disgruntled people who pay too much in tax say. Nothing like, let's go plan this plot with Whitmer. And for those who don't know, can you explain the convenient timing with her re-election campaign?
Yeah, the reasons why I was a suspect was first of all was the timing, because I thought it was tied to the presidential campaign. So because it's a key swing state, Michigan, right on the eve of the presidential election, right on the eve of United States Senate elections in Michigan, right on the eve of key U.S. House races in Michigan. And the FBI, within, I think it's a week before the election, announces dangerous militia anti-lockdown Trump-connected group tries to kidnap and kill or kidnap the dear good governor of Michigan. So I was suspicious right out of the gate. And then the other two factors were when they showed some of these defendants, I was like, these are people in their basement, on YouTube. These are not militia. These are not conspirators to revolutionaries to overthrow the government or to have any plot or plan. It looked like that Dan Aykroyd movie where they plot to kidnap a basketball player to help the Celtics. I mean, it was that laughable. Some of the stories.
I've never seen that movie, but it's not to be judgmental. I don't want to be judgmental as to these militia members couldn't have been legit criminals. You look at them, it's like there are career criminals, there are hardened criminals, and then there are people who are just not criminals, because not everybody can be a criminal. And not knowing anything about these guys, I've looked at the one who filed the motion to compel discovery. His Instagram posts are not what I would consider to be threatening anti-government messages. But some of the messages in here, they say, go find somebody who wants friends. And then you got 5 undercover FBI agents who come in and say, hey, let's talk about your interest of anti-government stuff. And then, hey man, someone gave the analogy. It's like an FBI agent infiltrating a group of teenagers and saying, hey, let's go throw stones at that window. And you get the kids to do it because they're easily impressionable. But for the involvement, it would have never happened.
Well, and that was the third thing is I knew the long history of the feds doing this. They've been doing this they've been doing it as long as law enforcement exists. But they really got accustomed to doing it in part in the 90s with some of the militia issues that you can look into whether Oklahoma City was a kind of a backfire of a plan gone AWOL. You have to look at Hush Hush at vivabarneslaw.locals.com for that. But post 9/11, they did it all the time. Darren Beatty with the revolver, Glenn Greenwald on his own independent Substack have both been writing about this, that it was not a surprise for them to see this, because if you knew that post 9/11, they wanted to prove to everybody how they were keeping the country safe. And they usually found nitwit teenagers they could sucker into a half-wit plot that wasn't real. And they would make it, we saved a building from being, some terrible event was just about to happen. And you dig in, you're like, oh, no, you just cooked this up to look good for the cameras. And this smacked of this, everything about this. And then we're getting just evidence upon evidence upon, when even BuzzFeed is saying, this kind of looks like the FBI did this whole thing. Yeah, then you know how bad it is.
They're saying it in a way that leads me to believe they're just trying to sensitize people. It's like, yeah, maybe it's entrapment, but at least we prosecuted 12 dudes who had a militia and were prone to being entrapped. Now it's going to be like prone to entrapment is going to be a crime. But at the end of the day, someone asked a question like, what happens to the FBI? Do they get spanked if the judge says this was clear entrapment? Where is the accountability? Assuming at the end of the day, a judge says this was obvious entrapment, shame on you. Where's the accountability and who does it?
Well, a study some years ago documented 2,000 cases where state and federal prosecutors or agents were cited for extraordinary misconduct by the courts that usually go out of their way to hear no evil, speak no evil, see no evil when it comes to the government. More than 2,000 cases where the courts themselves found egregious misconduct, and in only 2 instances was anybody disciplined at all. And just look at Spygate. Nobody was disciplined in Spygate. So Kleinsmith got a slap on the wrist.
I was going to say, whoa, Kleinsmith, what happened to him? He got a year.
He got a 1-year suspension that didn't even matter.
1-year suspension, retroactive to last year.
Exactly. It was completely unimpactful. He got a 1-year suspension for a time period he couldn't have got a job anyway. So no impact by the state bar, only probation, no criminal punishment of any consequence.
I was going to say, for the time period, he was on leave in any case, disciplinary leave, but he had just had a kid. He probably would have wanted to stay home anyhow. It is what it is, and it's offensive to everybody who is paying attention. So by and large, nothing's going to happen because who would have to look into it? Department of Justice? Like who would investigate that?
Yeah. The same reason why White Boy Rick is filing suit. It's that the system only investigates itself. And that's a good bridge into the next conversation.